possible.
All right, we're now joined by sports law attorney Dan Lust. It's been a while since we've had Dan on with some of the stories, though, this week. Thought it would be something to get into, including, Dan, we just had Mac Rhodes on about the NCAA and state law and what Baylor's philosophy is going to be. That doesn't mean it will be at Texas or A&M or Texas Tech and elsewhere. But what can the NCAA, what are they trying to do here? Just throw up a flare and hope it hits somewhere on this, you need to listen to us or else?
Yeah, I like that analogy. I think honestly, if we're really trying to unpack this at a high level, I don't think the NCAA can stand on legal ground with what they're attempting to do. Right? They're basically telling schools, listen, don't adhere to your state law, and if you want to adhere to state law, you can do it, but you're not going to do it within the NCAA. So, are they really, the NCAA really inviting schools to leave? No, they're not doing that. I think they're really just trying to delay and trying to buy some more time on the federal side. If you start to have a world where, Texas has a bill, and in particular, and I'm sure you guys covered it, the bill that we're talking about is the one that actively allows schools to, use words like facilitate, identify, support, enable NIL opportunities for student athletes. So that's, and it prevents the NCAA from punishing schools that act in that regard. Obviously, that is in violation of normal NCAA bylaws. But if your state law tells you can do it, you'd think you'd have some cover, right? Unless the NCAA is inviting a lawsuit under your state's particular law. So there's only about, I think it's like 8 states that have something like that that's being, going up through the houses and whatnot. And it's not a situation where you have 25 or 30 states that have passed it. Now, just as a little bit of historical precedence, just to kind of give you some indication of where we're going. Back, and I was on with you guys way back when, but, when the NIL era first started in November of 2019, when California passed it, the NCAA basically said, no, we're going to stand by our bylaw, and California is going to be an outlier. We're not going to do that. And then once you had about 25, 30 states that passed NIL, right, then NCAA turned around and waived that particular bylaw. So I think the NCAA is just trying to slow down the states a little bit. And they're trying to slow down those schools that are already or have already been conservative. Like I'm in New York, I work with some schools, I work with some collectives. I know that it's going to slow down the schools that thought they had ultimate cover, with the NCAA now saying they're going to enforce their NCAA violations, notwithstanding state law. So I think they're trying to delay, trying to wait for the federal bill to come in, wait for some more states to pass it before they really have to act on it.
Dan, what is the NCAA is hoping for benevolence here, I guess, on the part of their member institutions, but that's plan A. Do they have a plan B? Because they're not really famous for having a plan B.
No, I don't think there's a plan B at all. I think, truthfully, I've said that on social media. I think this is really just a delay tactic, and they're putting all of their eggs in the federal law basket. I think that's it. I think they've decided that they're not going to. And again, there's really one of two buckets here. They either wait for the federal law to come in, or, which we haven't talked about in this call, they start to get very aggressive with enforcement of their NCAA, the bylaws, the rules, which they haven't done, other than to save for this weird kind of quasi-NIL punishment for Miami women's basketball, of the 100+ Division I programs, 1,000 student athletes, the millions of deals have done. They found one little violation with Miami women's basketball. And that's with, 12+ schools under investigation, according to Sports Illustrated. They haven't ramped up the enforcement era. So they could do that. They could start trying to penalize schools, trying to go that route. But my gut tells me that they're not really going to do much of anything, as they've done for the last 2 years. And they're just trying to buy a little bit of time for the federal law. But I think all of their eggs are really in that federal law basket.
Dan, also talking before about there being this kind of line in the sand. I know the NCAA is technically the schools, but I'm sure you see all of the trends going on around this sport. Do you see some fractures developing as far as not just the haves and the have-nots, but certain power structures and just kind of where all of this is headed? Is this an entity as a whole, Division I through Division III, so on and so forth, that can remain as it is with some changes, or do you think there's inevitably going to have to be some type of a separation?
Well, it's funny. I think most people, and I've been on the phone today with my, fellow sports lawyers, and we all think that the NCAA is kind of thinly veiled thread at the end of that memo. It's if anyone's looking for it. It's that last sentence of question 6. But if you want to be a member of this voluntary, association, you have to follow our rules. So, if you read it on its face, it's basically inviting schools to leave, which, if we speak to enough people, no one really believes that's the case. No one believes the NCAA is truly doing that. But it's an odd time for them to even insinuate that schools should be leaving at a time where they don't really have as much power, or even are pretending to have as much power, right? They haven't really enforced any of these violations. I think it's premature to think that they're going to have some separate association that gets created. I know, that said, I know there's some stuff in the works kind of behind the scenes, and I think some of it's public, but, I think you have another entity, or a collection of entities, be it the collectives, that have some power. I'm not sure exactly what they're going to do. But you have the schools, you have the SEC schools, without saying anything inside information, like I'm sensing that there are people behind the scenes that sense that there is weakness in the NCAA and are trying to band together and really force some action on the NCAA's part. So we'll see. But I don't see a competitor to the NCAA popping up just yet. But I know those conversations are happening at some level.
Someone asked this in the chat room: if in fact the NCAA ever loses, like the super conferences in football, it's controlled by the college football playoff. Technically, it's not really the NCAA. If they were to ever separate, let's say you hear about these super conferences, if they ever separate, would that kill the NCAA?
I think I caught most of it. It cut out a little bit, but would it kill the NCAA if the super conferences left the league? Is that generally the question?
Yeah, if there was the so-called 220, 25 team conferences that just took over college football.
Yeah, so I mean, this is maybe a little bit of sports law history. We had something, there is some law in the books that allows for this. Go back to that weird College Football Association with that Board of Regents case back in the 80s. There is law in the books that says that schools can compete with the NCAA in terms of television revenue, television rights. You could have a super conference, whether you want to call it, I don't know, something akin to the College Football Association. You could do that. It's in the eye of the beholder. I mean, there was decades of college football where there was no national title game. It was just, you decide if people could vote on who the winner was going to be. The winner, was whoever people voted on the national champion. I think it's odd, and that would be a shame if that's what happened to college football. But the NCAA has really, for an entity that holds a lot of power, a lot of cards, especially with respect to college football. I'm not sure the NCAA is needed. I don't know, and obviously the NCAA doesn't control college football in particular, but by association of controlling the other sports, they do have some say over that space. So, yeah, I mean, I would hope that's not the end game here. But, there are very creative solutions being done in the world of college basketball. I think less so or I guess it's just basketball, pro basketball, semi-pro basketball. As an alternative, people, I guess you guys are following this too, but look no further, guys, than the NBA draft that happened about 2 weeks ago. I think 6 of the top 7 prospects in that draft, and only 2 guys were international. Yep. Actually, I think only 1 played college basketball. So, we haven't really seen that movement on the NFL side or on the college football side, be it a version of overtime elite. But, I think those conversations are happening. Someone's going to capitalize on the NCAA's, inability to adapt.
So you've heard about San Diego State sending letters back and forth with the Mountain West Conference, and I know, Dan, you got to go. Your thoughts about what is intent and what is we are leaving compared to what they sent to the conference, what the response of the conference was, okay, thank you very much, we now expect you to leave, and then the responses back and forth?
Truthfully, I haven't been following it that closely, but I'd say this is kind of a battle. I mean, I don't know if we know the forms behind the scenes in terms of what's in the contract, but you never want to be the breaching party, right? You always want some triggering event to give you some type of cover. So that's usually when you have a battle of the forms. Everyone's doing a little bit of CYA. But yeah, I guess we'll see what shakes out. We'll see if there's a lawsuit, there's any type of liquidation penalties, but we'll certainly see on that ground. Dan, thank you very much for your time and making time for us. We appreciate it. Okay, thanks, guys. Anytime. Dan Lust, sports law attorney, joining us mainly on the NCAA state law conversation.